Welcome to this explainer, where we're going to dive into a truly gripping constitutional battle. Today, we're unpacking a story about the fate of an abandoned child, the rigid walls of immigration law, and the fundamental rights that govern human lives. We'll explore exactly how the Constitutional Court of South Africa navigated a super delicate situation, one where the inflexible rules of the state collided head-on with the immediate, urgent needs of a vulnerable infant.
To really understand the human heart of this story, just listen to this quote. It comes directly from Mr. D.A.J. Uids. He was the senior member of the Cape Town Bar, appointed by the High Court as the curator ad litem, which is essentially an independent legal guardian tasked with representing the child. He was sent in to investigate Mr. and Mrs. Fitzpatrick, a British couple living in South Africa. Now, the Fitzpatricks were highly experienced foster parents. They had actually fostered 10 infants back in the United States, and his glowing, emotional report confirmed that they were, without a doubt, outstandingly capable and loving parents.
To unpack this complex case, here is our roadmap. We'll cover a family's legal roadblock, the unconstitutional adoption ban, the paramount principle, the state's valid fears, and finally, Justice Goldstone's ruling. Let's get right to it.
Part 1. A family's legal roadblock. So, picture this. In March of 1997, the Fitzpatricks moved to South Africa for work, and they quickly became approved foster parents there. By November, a tiny 2.5-month-old child who had been neglected and abandoned by his biological parents was placed in their care. The baby was briefly moved to another foster home the following March, but he just didn't settle, so by April, he was back with the Fitzpatricks. And a really profound bond formed between the couple, their 4 other children, and this infant. Eventually, the biological parents consented, and the Fitzpatricks decided to seek permanent adoption. But as they were about to find out, love and capability aren't the only things you need in the eyes of the law.
Which brings us to Part 2, the unconstitutional adoption ban.
The family hit a massive, seemingly impenetrable legal wall. At the time, the law drew a stark, uncompromising line. Under Section 18(4)(f) of the South African Child Care Act, if you were a citizen, you were fully permitted to apply to adopt a child born to a South African citizen. But if you were a non-citizen, like the Fitzpatricks, who held British passports, you were absolutely barred. There was no gray area, no case-by-case evaluation whatsoever. Just a blanket ban.
Recognizing how severe this was, the Fitzpatricks took the matter straight to the High Court. And amazingly, the Minister for Welfare and Population Development actually conceded that the law was unconstitutional. But here's the catch. The minister asked the High Court to suspend that declaration of invalidity for 2 years to give Parliament time to draft new legislation to fix the defect. The High Court agreed. So this meant the Fitzpatricks were stuck in total legal limbo. They were named joint guardians, sure, but they couldn't legally adopt the child for another 2 whole years. Mr. Fitzpatrick even had to delay a work transfer back to the U.S. just to see this through.
Let's look at Part 3, the paramount principle. This brings us to the supreme law of the land, which became the ultimate turning point when the case finally reached the Constitutional Court. The absolute anchor of this entire legal argument is Section 28, subsection 2 of the South African Constitution. When you're evaluating any law affecting minors, this is the bedrock.
The text is incredibly powerful. It says, "A child's best interests are of paramount importance in every matter concerning the child." It's intentionally broad. It's a flexible standard that dictates that individual circumstances, not blunt, sweeping rules, have to govern how the state treats a child.
Justice Goldstone, writing for a unanimous constitutional court, used this exact principle to tear down that absolute ban. The court reasoned that a blanket ban on non-citizens completely fails the best interest test because it just ignores reality. Think about it. What if a South African child is orphaned and their only surviving loving relatives live in another country? A rigid ban prevents that adoption. Plus, the court noted that South African nationality doesn't even guarantee that adoptive parents won't just emigrate the very next day anyway. The blunt rule simply wasn't serving its purpose of protecting the child.
Moving right along to Part 4, the state's valid fears.
Now, we have to look impartially at why the minister wanted that 2-year suspension in the first place. Immediately lifting the ban could create a regulatory vacuum. The minister had 3 very specific, valid fears. First, the department lacked the resources to do thorough background checks on applicants living abroad. Second, they feared they had insufficient legislative protection against child trafficking. And third, there was a total lack of infrastructure and bilateral agreements for international post-adoption monitoring.
This all ties into a concept called subsidiarity. Subsidiarity is the principle that intercountry adoption should strictly be an alternative. The primary goal should always be placing a child with adoptive parents residing in their country of birth. The state was genuinely worried that if the ban vanished overnight, foreigners might bypass local families, and children would lose their connection to their religious and cultural backgrounds. To highlight the dangers, the minister pointed to the Hague Convention on Intercountry Adoption. That convention establishes strict global systems to prevent the abduction, sale, or trafficking of children. The problem? At the time, South Africa hadn't signed or ratified it. The minister essentially argued, we need 2 years to build infrastructure that mirrors those international safeguards before we can let non-citizens adopt.
Finally, Part 5, Justice Goldstone's final ruling.
So how did the Constitutional Court resolve this massive tension between a child's immediate needs and the state's valid fears? Justice Goldstone essentially looked at the rest of the existing Child Care Act and realized it already contained a heavily regulated procedure. They don't just hand out adoptions. First, you have to get a mandatory report from a registered social worker. Second, the whole process is overseen by a trained judicial officer, a commissioner of child welfare. And third, the court is required to meticulously verify the applicant's financial means, their good repute, and deeply assess the cultural background of everyone involved.
And what about that very real fear of child trafficking? Well, Justice Goldstone pointed out that Section 24 of the existing act already made it a strict criminal offense to give or receive any consideration, cash or kind, for an adoption. The law was already on the books to deter and punish trafficking, completely eliminating the need for new legislation on that front.
The court then rapidly dismantled the remaining fears. Subsidiarity? Implicitly covered by Section 40, which makes courts weigh the cultural background of the child against the adoptive parents. What about the inability to do background checks abroad? Goldstone's logic was beautifully simple. If a social worker cannot verify a foreign applicant's background, the judge simply denies that specific application. The burden of proof is on the applicant. Ultimately, suspending the ruling for 2 years would only harm children right now, leaving them stuck in precarious foster care or institutions. And so, the hammer fell. The Constitutional Court confirmed that Section 18(4)(f) was invalid, and they completely overturned the 2-year suspension. The law was struck down immediately. Child courts were fully empowered to handle foreign applicants strictly on a case-by-case basis. Thanks to this clear constitutional logic, the Fitzpatricks were finally cleared to legally adopt the child they had loved and raised. The law caught up with the human reality.
As we wrap up this explainer, I want to leave you with something to think about. The Fitzpatrick case is a perfect illustration of the ongoing tension between bureaucratic regulation and fundamental human rights. A state absolutely has a duty to protect children from exploitation, but it also has a duty not to stand in the way of a child finding a loving home. So, what do you think? How should a nation optimally balance the necessary protection of its borders and infrastructure with the immediate paramount best interests of a child? It's a delicate balance, and one that continues to challenge lawmakers all over the world.